Hello. In this video, we'll go over the process and requirements for notifying parties to attend a hearing in small claims court. This process is referred to as serving court papers. We'll assume that you've already filed the plaintiff's claim, Form SC-100, and received back the stamped copies from the court clerk. Now, it's time to serve the court papers on the defendant. This process is designed to ensure that all parties are aware of the claim that you have filed. So the rules are strict and must be followed closely. If a mistake is made while serving the defendant, you may jeopardize the outcome of your case. There are 3 sets of rules that you must follow when serving court papers in small claims. 1. Who can serve court papers? 2. Where court papers can be served? 3. How court papers can be served. First, as the plaintiff, you are not allowed to serve court papers yourself. By law, someone who is not one of the parties to the case must serve papers on the defendant. In practice, it's wise to exclude anyone who stands to benefit directly, financially or otherwise, from the outcome of the trial. Instead, you must have a disinterested person, at least 18 years of age, serve the papers. Disinterested persons include the sheriff's office, a registered process server, or even a friend or family member. If you ask a friend or relative to serve court papers on the defendant, make sure that they complete SC-104, the form for proof of service, and submit it to the court at least 5 days before the hearing date. If you request that the sheriff serve the court papers, you must provide the sheriff with 2 court-stamped copies of Form SC-100 for each defendant, along with the signed sheriff's service instructions. It's important to note the sheriff charges a service fee of $40 for each defendant on whom they serve papers, unless a fee waiver has been approved. Process servers do not accept fee waivers, and their fees vary. Both the sheriff and a registered process server use their own proof of service forms, so follow up with them for the most accurate information. Second, small claims rules of service require that court papers be served in the state of California. There are only 2 exceptions to this rule. If you were involved in a vehicle accident, court papers may be served to the driver or registered owner in the state where they reside. Also, if you are involved in a dispute that concerns California real estate, court papers may be served to the property owner in the state where they are located. If you need to serve court papers on someone out of state and you don't fall under one of these exceptions, then you'll need to file your claim either in the state where the defendant will be served or in California General Civil Court. Third, you must use a valid method of service for it to be recognized by the court. There are 2 valid methods of service in small claims. Personal service, when the court papers are handed directly to the defendant in person, and substituted service, when the papers are handed to an eligible person who is at least 18 years old, other than the defendant. Eligible persons include a person who lives with the defendant or who is responsible for the location where the defendant works or receives mail. When using substituted service, an identical set of papers must be mailed first class to the defendant at the same address where the papers were left. Note that substituted service is the only method allowed when serving court papers on a corporation or public entity. When serving by personal service, the server checks box A on page 2. Enter the day, time, and place the plaintiff's claim was handed to the defendant. If the plaintiff's claim was instead served by substituted service, the server checks box B on page 2. Select the option below that correctly describes the eligible person who will receive the court papers. When serving court papers on a defendant that is a corporation or public entity, you'll usually check the box "An adult who seems to be in charge where person 1 usually works." Enter the day, time, place, and description of the person who was given the papers. To find the names of eligible people to accept court papers on behalf of corporations, limited liability companies, and limited partnerships, go to the California Secretary of State website and use the business search feature. When serving papers on a public entity, information on whom and where to serve is often found on the Claim for Damages form. In most cases, you will have already filed this form with the public entity before your small claims case was started, so check there first. If you are uncertain to whom to serve the papers, request the information from the public entity you are suing. And don't forget to complete the section about mailing a second set of papers after they were served. There are different deadlines for serving court papers depending on the method and location. These deadlines ensure that the defendant has adequate time to prepare for the hearing. See the table for the deadlines relevant to your case. Importantly, there are 2 additional methods of service that other courts may allow, but that are not allowed in small claims cases heard in Los Angeles County: service by publication in a newspaper and service by certified mail. If a person is named as a defendant in a small claims case, they have the option of filing a defendant's claim, which will be heard together with the plaintiff's original claim on the court date. A defendant's claim is a request for damages from the plaintiff. A defendant's claim may be related to the plaintiff's original claim, or it may concern an unrelated event. Either way, the defendant must complete SC 120 to file their own claim. If the defendant decides to proceed with a claim of their own, they must submit it to the court and serve papers on the plaintiff following most of the same rules as the plaintiff's claim, but with shorter time requirements. The defendant's claim must be served on the plaintiff at least 5 days before the hearing date. However, if the plaintiff's claim was served on the defendant 10 days or less prior to the hearing date, then the defendant's claim may be served as little as 1 day before the hearing date. If the defendant is unable to have the defendant's claim served, then the defendant should notify the judge on the day of the hearing. The judge may then decide to either hear, postpone, or dismiss the defendant's claim. This concludes our summary of serving court papers. Thanks for watching.